who have appeared here before you. Yeah, from Mount Elgon and the rest. My task is to demystify six myths that have been associated with the national discourse on the creation of new counties. So I want to debunk them. I want to put them to rest permanently so that people can have an honest and sincere debate on this quest for new counties. Ladies and gentlemen, the first myth is that to create a new county in Kenya, you need a referendum. That is a myth. That is not the law. The law is very clear in Article 188 of the Constitution.
Sorry, Mheshimiwa. Could we please have another copy from the Secretariat for what is being presented? Kindly.
Please, here.
Let's have another copy.
Yes,
the chair.
There are 2 copies for the co-chairs. Yeah. And so these other ones. Yes. Thank you very much.
Yes, Honorable Karoli. Just proceed.
Yes. Let them get to you so that you can follow my argument. Yeah. The first point is to demystify or to debunk the myth that you need a referendum to establish a new county. Our Constitution is very clear. Article 188, 1 and 2 provide as follows. If you want to create a new county, then Parliament shall establish an independent commission to review the boundaries of existing counties. Once that process is over, the next step is that review is then presented as a parliamentary initiative under Article 256(1), 2, 3, 4 of the Constitution by way of a bill amending the first schedule by introducing a new county. So the boundaries, what you need to know is that the boundaries of an existing county can be reviewed for several reasons, and there are 7 parameters set out in the Constitution.
You say 188?
188, 1
allows for
and 2.
Okay.
Article 188, sub-article 1 and 2 of the Constitution, as read together with Article 256, 1, 2, 3, and 4. Those are the operative articles of the Constitution of Kenya on the creation of new counties. Now, once the Parliament has established an independent commission, the next step is that review under Constitution.
I want my elders to be allowed in.
Yes, we have additional
please
elders.
Allow them to come in.
They must come in, otherwise there was no point of us being here.
There are additional elders from Teso. Let them be allowed in.
Just allow them. It's a few minutes, then we proceed.
The review will take into account 7 parameters. These 7, not all must be fulfilled. A review can be conducted on the basis of only one of the 7 parameters. And these 7 parameters are population, the need for infrastructure, both human and physical, historical and cultural ties of communities, the issue of costs, views of the communities affected, and the fulfillment of objects of devolution as outlined in Article 174, and also geographical features. Any one of those 7 parameters can inform a review. You don't need to fulfill all of them. And then the bill proposing that review and the amendment of first schedule by inciting a new bill is then processed under Article 256, 1, 2, 3, and 4 of the Constitution of Kenya.
Just hope that will help us understand how you navigate around 255.
I will come to that.
Yeah, please.
I'll come to that.
Yeah.
By way of parliamentary initiative. I want us to be clear on that. Now let me get to Article 255, 1 and 256, 5. I think that's where you are, correct? Articles 255, 1, I, 255, 1I, and Article 256, 5 of the Constitution of Kenya. These are the 2 articles that set out the amendments that require a national referendum. And our reading and conviction and the knowledge we have is that they do not apply to creation of new counties. Why? Because the review and alteration of boundaries of existing counties do not amount, note the words, do not amount to an amendment of the objects, principles, and structure of devolved government units. The 3 parameters that must be subjected to a referendum are where you are amending the objects of devolution, which are outlined under Article 174, when you are amending the principles of devolution, which are in Article 175, and when you are amending the structure of devolved government, which are outlined in Article 176. Review of boundaries do not fit there. So those articles do not apply. Now, it is our conviction that when you are amending the boundaries under 188, you are actually promoting the object of devolution. You are promoting giving life to the principles of devolution. And those new counties will embrace the same structure of government as outlined in Article 176. So there is completely no space for a referendum to create a new county. I hope we have debunked it. I hope you understand it. I hope the rest of the Kenyans are on the same page with us on that issue. We do not need a referendum to create new counties in Kenya. The second one, in no particular order, is the myth that new counties...
Karoli, yes, proceed. It's a contention that the structure of devolved government is provided for only in 176.
Yes, and the structure is that there must be a National Assembly and an Executive Committee. So and the new counties will have a National Assembly and Executive Committee.
And that varying the numbers of counties doesn't in any way...
Does not vary the objects, does not vary the principles, does not vary the structure.
Okay.
It gives life to those articles
by
creating new counties.
Proceed.
And let me bring, I think I'll jump my presentation and go to the third myth so that you understand it further. Let me go to the third myth. There's a myth in this country that 47 counties are the optimal number of counties that Kenya needs. It is a myth. It is a myth. And why is it a myth? The 47 counties as presently exist were not created on the basis of any scientific research. There was nothing. There was nothing to form their basis. As a matter of fact, there was not even a single occasion of public participation in the selection of the 47 counties. And they were provisional, and the committee of experts were very clear that we are starting with 47 as provisional. And their creation was arbitrary. Why was it arbitrary? Because people became lazy in Naivasha. People did not want to work and have a basis. The original provisions or proposals were 8 regional governments and 74 counties. Those 74 counties were based on scientific analysis by the late Odhiambo Mbai and his team. The 47 are created on the basis of existing administrative units created for a centralized government, not for a devolved system of government. They are the old districts that were gazetted as at 1992 by previous administrations. Now, that process was very unfair and skewed. There are areas that traditionally were excluded from being given district. But even then, the ones that were existing and gazetted by 1992, not all of them were made counties. And there are others that existed but had not been gazetted but were made counties. So basically, what we are trying to say is that the current 47 counties have not been premised on the objects, on the principles of devolution as recognized in our constitution. Yes. There are administrative units for a centralized system of government. They are not units for a devolved system of government. And then there must be a review on that basis. I hope we have demystified that myth. In other words, Kenya can have less counties or it can have more counties. But for purposes of equity, because the parameters that have been used to create the 47 have been used to deny other people who are deserving, it is only in the interest of equity, fair and justice that the counties that share the same parameters as the ones that currently exist be given the same opportunity. And I can give you examples.
Through the chair.
Yes.
What about Article 6.1 of the Constitution, which says that the territory of Kenya is divided into counties specified in the first schedule?
That is why I'm saying it can be amended